Hello, my name is Paul O'Kane and I'm going to be chairing today's event, which is organised by the Office of the Wards of Court in the Court Service with assistance from the new Decision Support Service. The Assisted Decision Making Capacity Act was signed into law at the end of 2015 and it's due to be commenced very shortly, after much preparation. The actual commencement is the responsibility of the Department of Children, Equality, Disability, Integration and Youth, and it is committed to commencement in the middle of this year, so we're almost there. The 2015 Act abolishes the existing wards of court system for adults. All adult wards will be reviewed by the Wardship Court and will exit wardship within 3 years at the latest. The Office of Wards of Court is responsible for managing that process, and that's what we're going to focus on today. It may be that someone who's a ward of court at present will be moving over to one of the supports on the new framework under the Assisted Decision Making Capacity Act. Under the Act, the Decision Support Service is set up to promote and manage the new framework. And in this webinar, we'll hear about the new service and the support options that are available. The Office of the Wards of Court has devised 5 scenarios to reflect some of the real-life situations of current wards and their committees. We're going to work through those scenarios later, and there'll be some time for questions and answers. More than 1,300 people registered for today's event, and we really thank you for your interest. So it really won't be possible to get to every question today, but we're going to do our best to get our answers to you on all those questions over the coming period in a frequently asked questions document. Before we move on to the 5 scenarios, I'd now like to introduce the panel for today's discussion. Firstly, we have Anya Flynn, the Director of the Decision Support Service.
Thank you, Paul, and thanks to all who've attended today. Yes, Director of the Decision Support Service, as Paul has mentioned, that's the new service established under the Assisted Decision Making Capacity Act. So we have a number of statutory functions under the Act to promote awareness and confidence, to provide information and guidance to people about their options under the Act, and information and guidance also to those who may be supporting them. We will register and regulate the new support arrangements, and that includes complaints and investigations function. And we have a duty also to set up certain panels, which you'll be hearing more about, and also to publish codes of practice. So we are future facing. We're not involved in the process to review wards of court, but if somebody does move over to one of the new supports under the framework, then that's where we may come into the picture. So thank you very much for being with us today. Thanks, Paul.
Thanks, Anya, and I'd now like to introduce Alice White of the Court Service.
Hi, I'm Alice White and I'm the Registrar of Wards of Court. Some of you may be familiar with me from working in the Wards of Court office previously as a case officer. I'd like to thank you for joining us today, and I know we're only going to tip the iceberg in terms of the queries and questions that you have, but we hope to be able to address as many of those as possible. And for those that we don't get to today, as Paul mentioned, there will be an FAQ document been circulated, but I'd also like to announce that we will be holding Q&A sessions here online in the office, starting this Thursday at 10 a.m. For those who would like to register to attend that, you could email wards@courts.ie and we will send you a link where you can log on. Priority will be given to the relevant person, their committee and family members. Thank you, Paul.
Thanks, Alice. And up next we have Rachel Quirk from the Court Service.
Good afternoon, everybody. My name is Rachel Quirk and I'm a case officer in the Office of Wards of Court since 2013. Some of you may already know me. I may be your case officer. If I'm not, you may have spoken to me in relation to queries that you have. Today, what I'll do is talk through what will happen in the court process to discharge a person from wardship so that they can then either be discharged to their own affairs or may go to the Decision Support Service. Thanks, Paul.
Thanks very much, Rachel. Next up, we have John Clear of the Court Service.
Hello, my name is John Clear. I'm the Head of Corporate Services and I'm the Accountant of the Courts of Justice. The Court Service manages and invests funds for which it has responsibility for on a prudent basis. As of the end of the financial year, September 21, total funds managed was 2.2 billion, of which 1.65 billion related to Wards of Court. As you know, ADM will bring about important changes. Investment decisions are influenced by a ward's investment time horizon. And as a result of the Act, the investment time horizon for many wards will be shorter and more predictable. Wards and ward minors previously invested in long-term funds such as the Growth Fund and the Moderate Diversified Fund will mostly be impacted. Beneficiaries invested in these long-term funds have since been de-risked into shorter term investments in preparation for the transition from wardship. This was a necessary step in protecting beneficiaries' funds against significant fluctuations in the financial markets between now and their date of the discharge, and in line with the fiduciary duty to act in the best interest of the ward. So thank you.
Thanks, John. And our final member of our panel is Elaine Kenny from the Court Service.
Thank you, Paul, and good evening, everybody. My name is Elaine Kenny, and I manage the civil operations support for all Circuit and District Court offices across the country. I'm responsible for the implementation of the Assisted Decision Making Capacity Act in the Circuit Court. We are currently working on finalising the processes for ADM, which includes the process for the review of a declaration of a former ward's capacity from the Wardship Court, together with the process for new capacity applications under the ADM Capacity Act, where applicants can apply to the court in relation to their capacity, the capacity of a relevant person who has never been a ward. There will be 9 offices dealing with ADM across the country, and these offices are based on Circuit Court jurisdiction. We're working towards ensuring consistency and standardisation across all those 9 offices to ensure that users receive the same level of service regardless of where they apply. Further information on those 9 locations and ADM can be found on the court's website. Thank you, Paul.
Thank you. So you've now met all of the members of the panel, so I'm now going to turn to the first of the 5 scenarios that we're going to consider this afternoon. Scenario 1, discharge from wardship, no decision support arrangement required. Emily was declared a ward of court at the age of 24 after the settlement of a personal injuries action. Emily has an acquired brain injury following a road traffic accident. Her parents, Anne and Brendan, are the joint committees of the person and estate. Emily's capacity has improved, and since her accident, she has attended various courses to help her become more independent. She recently rented an apartment and lives independently. On commencement of the 2015 Act, Emily applies to be discharged from wardship. On assessment by a court's medical visitor, it is determined Emily has capacity. And Rachel Quirk from the Court Service is going to consider this scenario.
So we're now going to look at the discharge process for Emily. When I refer to the relevant person, I'm speaking about the person who is in wardship at this time and who will be discharged. So Emily herself will make the application and lodges a notice of motion with this office. The medical visitor assesses the relevant person and provides a report to the Office of Wards of Court. A copy of the medical report will be sent to the relevant person and the committee. Documents are then prepared by their solicitor. The Office of Wards of Court prepares copies of orders and schedules of assets and any other relevant documents. These documents are exhibited in a grounding affidavit filed by the solicitor on behalf of the applicant. When papers are checked in the Office of Wards of Court and are in order, the notice of motion issues. The solicitor must serve the motion and documents on the relevant person and the committee. A booklet of documents is filed with the affidavit of service. A return date is given for the hearing, which can be in person or a remote hearing. The discharge order is signed after the court date. Emily is then discharged and her funds are sent to her bank account. Paul.
Thanks, Rachel. We'll now move on to scenario 2, which is discharge from wardship, decision-making assistant. Tommy is 32 and was declared a ward of court in 2020 following the settlement of a personal injuries action. Carol and Pat, his siblings, are the joint committees of the person and estate. Tommy can communicate using assistive technology and lives with the assistance of 24-hour carers. On commencement of the 2015 Act, Carol applies to have Tommy discharged from wardship. On assessment by a court's medical visitor, it is determined Tommy has capacity. Tommy expressed his will and preference to appoint a decision-making assistant so that they can communicate on his behalf with his utility providers. And to consider this scenario, we're going to hear from Rachel again from the Court Service and Anya from DSS.
So in this case, Carol, one of the committee members, lodges a notice of motion. The medical visitor assesses the relevant person and provides a report to the Office of Wards of Court. A copy of the medical report will be sent to the relevant person and the committee. The documents are then prepared by their solicitor. The Office of Wards of Court prepares copies of the orders and a schedule of assets and any other relevant documents. These documents will be exhibited in a grounding affidavit filed by the solicitor on behalf of the applicant. When the papers are checked in the Office of Wards of Court and are in order, the notice of motion issues. Solicitors must serve the motion and documents on the relevant person and the committee and the applicant. A booklet of the documents is filed with an affidavit of service. A return date is given for the hearing, which can be in person or a remote hearing. In this case, the discharge order signed after the date will include any further directions and the funds will be returned to Tommy. The decision-making assistant must give notice to the Director of the Decision Support Service. Thanks, Paul.
And is that where I come in, Paul? Yeah. So the Decision Support Service hasn't been involved in the process up to this point. And Tommy, who has been found to have capacity and has had his assets and his decision-making restored to him, is opting here for the least involved form of support available under the Assisted Decision-Making Capacity Act. So this is the lowest tier, the decision-making assistant. So Tommy is choosing somebody whom he knows and trusts to step into this role, and it seems likely here that he might ask Carol and or Pat to be the decision-making assistant or assistants in this case. This means that they are going to be able to assist him with decision-making around communicating with his utility providers. So they will put together a decision-making assistance agreement, setting out the decisions that Carol and Pat or either of them are going to help with. And as Rachel has said, that will be notified to us in the Decision Support Service. And that means that here is confirmation that Carol and Pat are able to perform this role. And that is limited to helping him to take up relevant information, helping Tommy to understand that information, to communicate what he wants to do, and to make and express his decisions. And they'll help him ensure that those decisions are carried out. Tommy is very much still making his own decisions in this scenario. Thanks, Paul.
Thanks very much, Anya and Rachel. We'll now move on to scenario 3. So scenario 3 is a co-decision making agreement. Billy was declared a ward of court in 2015 when he was 39 years of age. Billy has an intellectual disability and he resides with his sister Siobhan, who acts as his committee. On commencement of the 2015 Act, Siobhan makes an application to have Billy discharged from wardship. The medical visitor report states that Billy can express his will and preference, especially when presented with limited options to choose from. The medical visitor assesses that the appropriate tier of decision support needed is a co-decision maker to assist Billy, particularly in relation to his finances. And to consider this scenario, we'll hear from Rachel from the Court Service and again from Anya in DSS.
So in this case, Siobhan will lodge a notice of motion. The medical visitor again assesses the relevant person and provides a report to the Office of Wards of Court. A copy of the medical report is sent to the relevant person and the committee and applicant. Documents will be prepared by their solicitor. The Office of Wards of Court prepares copies of any orders and a schedule of assets and any other relevant documents. These documents are exhibited in a grounding affidavit filed by the solicitor on behalf of the applicant. When papers are checked in the Office of Wards of Court and are in order, the notice of motion issues. The solicitor must serve the motion and documents on the relevant person and the committee. A booklet of documents is filed with the affidavit of service. A return date is given for the hearing, and this can be an in-person hearing or a remote hearing. The discharge order in this case, which is signed after the court date, will include any further directions, including registration with the Decision Support Service. Once the co-decision maker registers with the Decision Support Service, the discharge order comes into effect and funds in court will be returned. Thanks, Paul.
And that's where the Decision Support Service would step in. So as before, we haven't been involved in the process up to this point. But what will now happen is that we will take over the supervision of the co-decision making agreement. So this is the middle tier support. Billy is going to, again, he's in charge of who the person would be. So he may well here choose Siobhan, his sister, to be his co-decision maker. And that means that he is going to take specified decisions jointly with Siobhan, and they could be decisions about his personal welfare or his property and affairs, and those are both quite broadly defined categories under the Act. So the co-decision making agreement is drawn up and sent to us for registration. That has to be done on notice to certain other parties who are entitled to raise objections, which the DSS must consider. But all we being well, we would then register that agreement and hold it on a searchable register. Our functions after that are to help the co-decision maker to do the best job that they can be and to supervise them in their functions. So they're obliged to apply the guiding principles, which are in the 2015 Act, and that includes respecting Billy's will and preferences. And the co-decision maker also has to file certain reports with us periodically so that we can ensure that all is going well. And we would also keep the co-decision making agreement under review and ensure that Billy's capacity is as it was when the co-decision making agreement was put into place. Thanks, Paul.
Thank you, Anya. We're now going to move on to scenario 4, and scenario 4 is a decision-making representative. Sarah is 86, and she has been resident in a nursing home for 4 years as she requires full-time care. Sarah was diagnosed with dementia 7 years ago and moved to the nursing home due to her level of care needs. Sarah's nephew Seamus is her committee, and he applies to have Sarah discharged from wardship. The medical visitor assesses that the appropriate tier of decision support needed is the appointment of a decision-making representative. And to consider this scenario, we're going to hear from Rachel from the Court Service, Anya from DSS, and also from Elaine in the Court Service.
So in this scenario, Seamus, whose nephew is a nephew of Sarah's, lodges a notice of motion. The medical visitor assesses the relevant person and provides a report to the Office of Wards of Court. A copy of the medical report will be sent to the relevant person and the committee, in this case the applicant. Documents are then prepared by their solicitor. The Office of Wards of Court prepares copies of orders and a schedule of assets and any other relevant documents. These documents are exhibited in the grounding affidavit filed by the solicitor on behalf of the applicant. When papers are checked in the Office of Wards of Court and are in order, a notice of motion issues. The solicitor must serve the motion and documents on the relevant person and the committee. A booklet of the documents is filed with an affidavit of service. A return date is given for the hearing, which can be an in-person hearing or a remote hearing. In this case, the discharge order is forwarded to the Decision Support Services with details of the decision-making representative. When the decision-making representative registers with the Decision Support Service, the funds will then be released to the relevant person. Thanks, Anya.
Thank you, Rachel. And again, this is where the Decision Support Service would come into the picture. So the decision-making representative takes their authority from the court order. So the judge will have set out in the order the decisions which the decision-making representative, and let's call them the DMR, which the DMR is allowed to take. And again, they could be decisions about Sarah's property and affairs or her personal welfare. And let's suppose that Seamus then has been appointed as her decision-making representative. We will be engaging with Seamus from early on to ensure that he has a good knowledge of what his role consists of and what his obligations are under the Act and under the decision-making representation order. He has to apply those guiding principles again. He has to consider Sarah's will and preferences in all that he does, or do his best to ascertain those will and preferences. There will be a code of practice for decision-making representatives and indeed for all the different tiers of support to help with further guidance. If Seamus has responsibility here for Sarah's property and affairs, then at the 3-month mark, he will be filing with the DSS a report setting out Sarah's assets and liabilities and a projection of her income and expenditure. And we will consider that. And there will be templates available from the DSS so that should be as straightforward a process as possible. Thereafter, he would be reporting to us on an annual basis. And we will be keeping all of that under review to ensure good compliance, but also to support Seamus to be the best DMR that he can be. There are always certain limitations on what any decision-making representative can do. As I've said, they take their authority from the court order. They can't become involved in decision-making about keeping anybody away from seeing the relevant person. The Act says also that a DMR doesn't get involved in medical decision-making about life-sustaining treatment. So I think that is enough for me on that one, and we'll be picking up some of the same things, I think, in scenario 5. Thanks, Paul.
Thank you, Anya.
Pardon me, Lane taking over in review. Thank you.
So the first anticipated interaction Sarah, the relevant person in this scenario, will have with the Circuit Court is for a review of the declaration of her capacity. And this review must take place not later than 3 years from the date of declaration in the Wardship Court. The Wardship Court shall make an order that the capacity of Sarah, the person the subject of the declaration, be reviewed by the court not later than 12 months from the date of declaration in the Wardship Court, or not later than 3 years from the date of declaration in the Wardship Court, if the Wardship Court is satisfied that the person, the relevant person, is unlikely to recover her capacity. However, an application for review can be made to the court at any time by Sarah, the relevant person, or by consent of the court, any person who has attained the age of 18 and who has a bona fide interest in the welfare of the relevant person, such as the DMR. Okay, thank you. I'll hand you back to Paul.
Thanks, Elaine. So now we're going to come to the last scenario that we're considering this afternoon. It's scenario 5, and that's decision-making representative, appointment of a DMR from a panel. Roy is 75, and he has resided in long-term care with a disability service since he was 15. He was declared a ward of court in the 1970s, and the General Solicitor was appointed as his committee. He is an only child, and both his parents have passed away. The service provider is not aware of any relatives, and he has no visitors. The General Solicitor as committee applies to have Roy discharged from wardship. The medical visitor assesses that the appropriate tier of decision support needed is the appointment of a decision-making representative, or a DMR. So again, in this case, we're going to hear from Rachel and Elaine from the Court Service, and also from Anya from DSS.
So, in this case, the General Solicitor, who acted as committee during wardship, will lodge a notice of motion. The medical visitor assesses the relevant person and provides a report to the Office of Wards of Court. The copy of the medical report is sent to the relevant person and the committee and applicants. Documents are then prepared by the solicitor. The Office of Wards of Court prepares copies of orders and a schedule of assets and any other relevant documents. These documents are exhibited in a grounding affidavit filed by the solicitor on behalf of the applicant. When the papers are checked in the Office of Wards of Court and are in order, the notice of motion issues. The solicitor must serve the motion and documents on the relevant person and the committee. A booklet of the documents is filed with an affidavit of service. The court will seek the names of 2 DMRs, decision-making representatives, from the Decision Support Service panel of expert DMRs. A return date is given for the hearing, which can be in person or a remote hearing. The discharge order, which is signed after the court date, will include any further directions, including the registration with the Decision Support Service. A copy of the discharge order is forwarded to the Decision Support Service, and funds can then be released from court. Thanks, Paul. Sorry, Anya, you're next.
Am I next? I am, yes. Yes, so again, this is where the Decision Support Service comes into the picture slightly earlier because we have been called upon by the court to nominate from our panel decision-making representatives, and then the court will choose a decision-making representative or representatives plural to step into this role. The court will have carefully considered, obviously, up to this point, the wishes, the will and preferences of Roy. The court will have looked at the complexity of Roy's affairs. And in this case, it would seem that there aren't existing family relationships that have to be considered. Ordinarily, that is something that the court would be considering before turning to us, the DSS, to make nominations from our panel. So the panel of decision-making representatives is one of a number of panels which we are required to set up under the Act. We have gone through an extensive recruitment and selection campaign to put that panel in place, and there will be, I think, 126 different DMRs who will be available on a regional basis, both to the Wardship Court and then under the Part 5 applications available in the circuit courts around the country. So they have particular expertise. They are drawn from a range of professional backgrounds, legal, social work, and so on. Again, thinking about the need to step into decision-making roles in relation to property and affairs and also personal welfare matters. Once appointed by the court and having been made the subject of this decision-making representation order, their duties and their engagement with the Decision Support Service is exactly the same as in scenario 5. They have the same obligations under the decision-making representation order. So they take their authority from that order. They can't do anything unless it's authorised by the order. And they also have to apply those important guiding principles, again, thinking about will and preferences. And then, like the family member DMR, they are acting as an agent and taking decisions on behalf of the person. And then, like the family member decision-making representative, the panel member DMR has to turn in reports to us at those periodic intervals at the 3-month mark if they're dealing with property and affairs matters, and thereafter on an annual basis. And the whole decision-making representation order is something which can also be re-entered before the court for variation or for discharge. So it's very much kept alive. And as I've said already, our duty, as we see it, is to support the DMR to be the best supporter that they can be, having regard at all time to Roy's rights in this instance. Thank you very much.
Thank you, Anya. Again, like the previous scenario, the first anticipated interaction Roy, the relevant person in this scenario, will have with the Circuit Court is for a review of the declaration of his capacity. And that review must take place not later than 3 years from the date of declaration of his capacity in the Wardship Court. Again, the Wardship Court shall make an order that the capacity of Roy be reviewed by the Circuit Court not later than 12 months from the date of declaration in the Wardship Court, or not later than 3 years from the date of declaration in the Wardship Court, if the Wardship Court is satisfied that the relevant person, Roy in this instance, is unlikely to recover his capacity. However, again, an application for review can be made to the court at any time by Roy, the relevant person, or by consent of the court, any person who has attained the age of 18 and who has a bona fide interest in the welfare of the relevant, and again, that can be the DMR. Thank you, Paul.
Thanks very much for the input on all of those scenarios. Thanks to Elaine, to Anya, and to Rachel. So as outlined at the start, what we're going to do now is take some questions. As I mentioned, there are 1,300 people registered for the event, so we won't be able to get to all of the questions, but we will be compiling an FAQ, frequently asked questions document, which will be circulated. So the format will now have this: I'll ask the question, and then any one of our panel can then respond to the question, or if they're feeling unhappy about the question, they'll virtually look at each other and see who's going to jump in and answer the question. So I'll start off with an easy one. There's a question which asks, will there be a recording of this event made available?
Yeah, I can answer that one. There will be a recording made, and anybody can apply. Anybody who's here can apply to this office to register for a copy of the recording. So that was definitely an easy question, Paul. Thanks for that one.
That was a starter.
And add to that, I think there'll be a link provided that anybody who wasn't able to attend today for whatever reason will be able to go and access the link and view a recording of this.
So that was effectively a starter for 10. So they're going to get progressively harder from now. What will reporting to DSS be like? How will I know what I need to put in a report? And can I get into trouble if I don't put in the right sort of report?
Definitely one for me. Yes. As I think I said in answer to one of the scenarios, we will have template reports available to provide a good sort of guidance and structure for people so that they know what to put in. As I mentioned, those reports have to be turned in on an annual basis, but also at the 3-month mark if somebody has been appointed to take decisions about property and affairs. So we'll be providing good guidance from the start. Obviously, this is new and we want to reassure people. So as soon as we become informed of a decision-making representation order, we would see it as our role to engage with the person who's been appointed to get a good understanding of them and their circumstances and any difficulties that they feel they might experience and try to help them work through those. As to whether you can get into trouble, again, our idea is to work with you to ensure that compliance is something which is easy to manage. There is a certain flexibility in the Act so that if what you turn into us is an insufficiently complete report, we don't just say, well, that's it, and take next steps to escalate. Instead, we'd be going back to you and saying, look, let's revisit that report, let's get it into better shape and ensure that the relationship is working well. As to whether you can get into trouble, well, there is an escalation to court, back to the circuit court on the civil side. If we just can't get the relationship to work, if this is somebody who isn't suitable or willing or able to comply with the role to which they have been appointed, and we can apply to the court to have the decision-making representative replaced. If things were to go really badly wrong, and there are bad actors, let's not pretend that sometimes genuine safeguarding issues don't arise, then the Act actually does create a number of criminal offences if somebody is, for example, engaging in fraud or whatever it might be, or abusing or neglecting the person that they've been appointed as decision-making representative for. But those are rare cases, and let's not get too alarmed about this becoming, a heavily policed arrangement. And there is also that complaints and investigations function that the DSS has that I have mentioned. So if somebody were concerned about how a DMR was acquitting themselves in the role, if the view was that they were stepping outside their role, if they weren't applying the Act properly, then those are grounds of complaint that could be brought to us, but we would be investigating that. Again, trying to make the relationship work, trying to resolve issues. We have an opportunity to resolve them informally if we can, or the route might be to court to have the person replaced in that role. But we would hope, as I say, to work with the supporter in the delivery of their duties as far as possible. Thank you.
Thanks very much, Anya. It's a very comprehensive answer. This is one probably more for our colleagues in the court service. I'm a committee of a ward of court. I want to make an application for discharge. How much will the application cost, and where do the funds come from to pay for the discharge?
Okay, and I'll take that question. If the relevant person has funds that are lodged here in court, the cost of the application will be met from their funds in court. If the relevant person doesn't have access to funds or has no income, well, then they're entitled to bring an application for legal aid and to be legally represented by a solicitor from the legal aid panel to bring the application. Also, in addition to that, family members will be entitled to get legal advice from the legal aid service if they meet the criteria.
Thanks very much, Alice. The next question is, what if I don't like how a decision-making representative is making decisions for my family member? What if they're not respecting my will and preferences? What can I do in such a scenario?
Okay, so I suppose that supposes that here's a family member who has not been appointed to the role. So a different person, or perhaps a panel member, has been put in place to carry out the decision-making representation order. So I touched on some of this already in my first answer, so that that person who has a genuine concern could raise this as a complaint to the DSS. And again, we would look into the matter to try and understand why things hadn't gone well, why this other family member, third party, was concerned about how the DMR is doing their job. Are they departing from the terms of the court order? Are they failing to respect will and preferences, or whatever it might be, the grounds of complaint are set out in the Act? We can hear from people concerned, we can take up evidence, we can look for various pieces of documentation. We will have people called general visitors that we can commission to gather up evidence and present a report to us so we can make the best decision about how to proceed. It's also true to say, and I think it's related to this question, that the decision-making representative as an intervener, again, having to consider the person's will and preferences, is also told under the Act that they have to confer with people close to the relevant person. So the decision-making representative isn't being authorised to sideline another family member, perhaps the family member who's concerned in this case. They should actually be engaging with that person, because that's a person who's close to the relevant person and is able to give a good understanding of that person, is able to give information about their will and preferences and beliefs and values. So a family member shouldn't necessarily feel sidelined because they haven't been appointed to the formal role, and also should know that there are opportunities if there are genuine concerns about how the appointed DMR is carrying out their duties.
Thanks, Anya. There's a couple of questions here in relation to the medical assessment, so I might take a couple of these together to make it easier for the panel and just to roll them up. Will existing medical assessments of wards continue to apply, or will there be fresh assessments in view of these developments? And I'll follow that question up with a subsequent subsequent question. Who will appoint the medical advisor? Might they be known to the relevant person?
Okay, and I'll take that initially to start off. The court service medical visitors will be the people who will carry out the assessment. Any family member who wants to have an additional assessment done can do so as well and present that to the court. It can be submitted to the office to be taken into consideration alongside the court's medical visitors report. We will look to ensure that a medical visitor who is familiar with, who has worked with the relevant person previously and has some awareness of their background, and we will look where possible if that person can carry out the assessment. So there would be a familiarity and possibly an existing relationship there.
And then just as you covered, so they may be known to the relevant person, the medical advisor?
Yes, they may be known, and where possible, if we can get somebody who does have that pre-existing relationship with the relevant person, we will try to use that medical visitor to carry out the assessment.
And Paul, if I might just come in there, I suppose it's to say that capacity under the Assisted Decision-Making Capacity Act is assessed in a functional way. And that means not just looking at whether somebody has a diagnosis. In fact, the diagnosis, whatever it might be, isn't actually relevant to the finding in relation to a person's capacity. Instead, it's about looking at what decision the person, or decisions that the person needs to make, and looking at their ability to take those decisions. So that's in a time-specific and issue-specific way. And the way that capacity is considered under the 15 Act then is whether somebody can understand the information relevant to making the decision, to retain the information for long enough to make a voluntary choice, to weigh up and use that information, and then to communicate what they want to do. And that's communicate with appropriate assistance if necessary. So it isn't a medical model of capacity. It's not just does somebody have dementia, an intellectual disability, or an acquired brain injury. Those are only relevant if they're actually impacting on decision making. So that's the approach already, but it's being put into black letter law under this Act.
Thanks, Anya. We have a couple of questions in relation to decision-making representatives. The first of the two what happens if the decision-making representative passes away before the person they're representing?
Oh yeah, well, that would come back before the court. Now, there is an opportunity for there's an opportunity for the court to appoint decision-making representatives to act jointly or jointly and severally, which means they can either act together or they can act independently in respect of the same decision. So potentially the surviving DMR could continue to act. It would depend on how the order was framed by the court in the first place. It may be an occasion for the matter to come back before the court to look again at the decisions that need to be taken and at the ability of the surviving decision-making representative to continue to carry out that role. Decision-making representation orders, as a few of us have been saying, are something which are kept under review anyway and capable of being brought back before the court to ensure that it's still working well.
And just a follow-up question to that, do you have to live in Ireland to be a DMR? And I presume in this question they're using Ireland in the concept of the state rather than.
I think they are, Paul.
Only Northerners can spot that.
The Act isn't actually prescriptive about that. It does talk about availability, suitability, and willingness to act. So it doesn't actually set kind of geographical limitations around that. I suppose it's about your ability to do the job. So you could be living outside of the state and still able to perform that role. I do know that our panel DMRs are from within the state because they're professionally registered with Irish organisations. So it could arise, and remembering again that it's about the will and preferences of the person. So it may well be that you want somebody who is, outside of the borders, who is best placed to do that role. I don't know if any of the others have any view on that, but I don't think the Act is prescriptive in that way.
And then we have a question: Can an individual use a decision-making agreement privately without the courts? And if so, is this accepted by the new system?
Sounds like was that decision-making assistance agreement?
Actually, the word assistance, may have been dropped out in the question.
If I'm right, then that's the lowest tier support, the one that came up in scenario 2 that we were looking at. The courts aren't involved in a decision-making assistance agreement, unless it were to go wrong and become the subject of a complaint. That's the least interventionist, the lowest tier, kind of lightest touch arrangement. If it's going to be a legal decision-making assistance agreement, then it is something which would be created under the Act, drawn up in the way that the Act prescribes, and regulations will fill in some of the detail there, and it would be notified to us in the DSS. People have all kinds of ways, though, of being supported in decision making, and that obviously happens at present. Only a minority of people are wards of court, so people who may have some difficulties with their decision making are supported in all sorts of ways at present, and those may be completely valid arrangements which can continue. We mustn't assume that everybody needs to kind of locate themselves somewhere in the new framework. So if that is happening in a way which is consistent with the person's will and preferences, if they are happy to be able to say, I want this person in the room or sharing in my information or supporting me in assisting me to make the decision, then that may well be an agreement which, an arrangement so-called, which can continue. But a decision-making assistance agreement as set out in the Act should be made under the Act following the processes that the Act sets out.
Thanks very much. We have a question. Can anyone be referred to the Decision Support Service from the community if there are concerns about their capacity? Or is there a specific criteria for referral to the DSS?
I think, that supposes perhaps an application to court, does it? So I don't know, Elaine, if you want to come in there about how the Part 5 process for somebody who isn't a ward already would be embarked upon. I can come in then on the lower tiers if need be.
Apologies. So under Part 5, that's where an application can be made by somebody. There may be a family member or a friend who can make an application for the capacity of the relevant person, to be assessed, and a declaration by the court. Sorry. So that applicant may be the DMR, or there may be somebody else who they can who wish to act as the DMR. So that would be the only scenario that it would come before the court for a DMR.
So Paul, yeah, that's the top tier support. The DSS, as I was saying, in the course of the scenarios, isn't actually, as Lane was saying, involved. At that stage in the process, we would only become involved then if the court were to look to us to nominate DMRs from our panel, and we become involved then subsequently in the supervision of the arrangement. At the lower tier supports, if anybody thinks that somebody they know might benefit from those supports, by all means, send them the way of the DSS, and we can provide that information and guidance. And through our system, then we'll have a customer facing portal, you can then work through and create one of the arrangements, and we will have manual and paper-based workarounds if those are required. I don't think I mentioned our website address earlier, but it is www.decisionsupportservice.ie, where you can find out lots more about the Act and the support framework.
Thanks, Anya. The next question covers, excuse me, it's the court service side of the house. What does this mean for in-process ward of court applications or potential ward of court applications?
So I'll take that question. The office is still at the moment accepting ward of court applications. We will continue to accept them now and up until the date of commencement of the Act. There is transitional arrangements going to be included in the Amendment Act that will allow the office to continue processing and declaring people wards of court post-commencement, and in that expectation, like I said, we'll continue accepting and processing applications.
Okay, thanks for that. Sorry, the next question is, could you outline the fundamental difference between decision-making assistant and a co-decision-making agreement? The questioner says they didn't get a sense that it was clear from the scenarios that we outlined.
Okay, and more information is available on our website. So the decision-making assistant is just somebody who is stepping into a role to help you access information. They'll help explain that information to you and assist you in communicating what you want to do. You are still taking the decision by yourself. The decision-making assistant is there to help, and their role doesn't go beyond that. Co-decision-making then is a more formal arrangement. It is an arrangement which is registered with us in the DSS, and there is an application, and there are pieces of supporting documentation, capacity statements, character references, and so on required. And we would review all of that before putting it on our register. And we have to listen to the objections of notice parties who may not think that this is an ideal arrangement, or that the particular co-decision maker is well placed to step into that role. And once that co-decision making agreement is registered with us, then any decisions which that co-decision making agreement covers have to be taken jointly for as long as the co-decision making agreement is in place. The co-decision maker, as the Act says, it spells out the co-decision maker's functions, while taking those decisions jointly with the relevant person, does have to, if there's a disagreement about what to decide, there's what's called a duty of acquiescence, which means that the co-decision maker has to do what the relevant person wants, unless they think that there's going to be serious harm as a result. So it's very much more involved. It is quite different from the decision-making assistant first tier. It is a legal document which prescribes joint decision-making only in the matters that it covers, and they're reporting to us, supervised in the way that I've described, and all kept under review to make sure that the person's capacity when they entered into the co-decision-making agreement is maintained and is the same for as long as the agreement is in place. More information is very much available through our website, and obviously, if anyone has any outstanding questions on that theme, do send them along.
Thanks, Anya. This question may be one for John, potentially. Who will be responsible for the costs arising from applications to discharge?
Well, I'm not sure as to whether that was answered previously as regards the costs. So as regards, say, the application or the fees, if that's what they're talking about, then it'll be coming out of the funds that the person has in court. And I think Alice spoke about that earlier on.
I did, and just to add again, in case anybody missed that, if the relevant person does not have funds or assets themselves, there are amendments coming to Part 6 of the Act that will provide for the application of application to the Legal Aid Board and for the appointment of a panel solicitor under the Legal Aid scheme to assist.
Thanks for that. So obviously we've outlined the fact that there are 3 years to complete this change. What happens if there's no application in that time? Are you encouraging people to apply as early as possible, or what sort of turnaround time are you aiming to have in terms of from the application to decision?
So I'll take that question. And yes, we would encourage people to submit applications. While there is a 3-year time frame, we don't want to be left with a situation where we have very few applications coming in the first and second year and then have to deal with the majority in the final year. We would encourage people to submit their application when they can. We expect applications for discharge from the time you first lodge a document to take approximately 4 months till the final discharge order is made, just in terms of the level of legal documents that will be required to be drawn up by your solicitor and to be submitted to the office, and also to allow for appointments with the medical visitor and for those assessments and reports to be submitted as well.
Okay, thank you. In relation to solicitors, when the persons are different, does the applicant and the relevant person need separate legal representation?
No, they don't require separate legal representation. However, if the relevant person wants to have their own legal representation, they can appoint a solicitor themselves, or the applicant can go and look for independent legal advice if they want to, but it's not a requirement. It would be an option though, if either party wanted to do that.
Thank you. If I don't have family, who could my representative be?
Representative being the top tier. So if we assume that is the DMR appointed by the court, then that is where the panel might be called upon. So in the scenario 5, I think that we looked at, that was where the person had been represented by the general solicitor as their committee for many years. So in that instance, then we saw the court calling upon the DSS to nominate from our panel of DMRs, and the court made an appointment from there. So I don't know if the question is referencing the lower tiers of support. There aren't panels of decision-making assistants, there aren't panels of co-decision makers. So that panel refers only to the top tier court-appointed support available to be appointed either by the circuit court for somebody coming new into the system, or by the wardship court as part of this Part 6 review that we're talking about today.
And in terms of those panels, are the panels, will the people comprising the panels, is that information in the public domain, or will that be in the public domain, or is that something that won't be in the public domain?
I think there's no reason why it shouldn't be in the public domain. It's a panel which is held by us. As I mentioned, there are 126 professional people on it. Well, we're just finalising the membership of that panel at the moment. In fact, we've begun training the panel member DMRs today, and they'll go through, a vetting reference check, checking out their credentials and making sure that they are fit to serve on the panel. I know that the Mental Health Commission would have experience in the past of publishing the details of the people on their panel, so I don't see that there'd be any reason to do it differently. It's the court who asks for the nominations, and we'll be operating that panel on a rotational basis, subject to where in the country the need arises, or any particular aspects to the case which would necessitate a certain sort of expertise. I suppose that could happen as well. And then those nominations will go forward to the court for the court to make that decision about who will take on the role of DMR. And as I've said, then once appointed, that panel member DMR has exactly the same duties and responsibilities and functions under the Act as a non-panel member DMR.
Thanks very much. And we have another question here. My child is 15 and is a minor in wardship. What will happen when they become an adult?
I can take that question. The Office of Wards of Court will continue to have responsibility for minors who are in wardship, but when a person gets to the age of 17 and a half, an application can be made for discharge from wardship. So by the time they're 18, the application would need to be made so that they can be discharged from wardship. And again, that will, once that application is received, the medical visitor will go to assess the person and see what the relevant tier of assistance and support is that they need. And if necessary, then they would go through the same process as we mentioned a number of times earlier in relation to how somebody is discharged from wardship. So the process there, if they're already in wardship, will be exactly the same.
Thanks very much. We have another question here. Can I continue to use the committee account set up in wardship to manage funds under the new service?
I suppose I can answer that one too. No, well, the committee will no longer exist once discharge of wardship happens, so it won't be a position anymore for a person to have. So it wouldn't, by default, then you couldn't run an account as a committee. So the relevant person will need to have their own account, their own bank account set up in order for their funds to be released from court to be used by themselves. Depending on the level they're at, they'll have either a DMO or a co-decision maker or an assistant to help them, or maybe they won't need anybody at all. But a committee account will no longer be relevant and can't be used anymore for funds for a relevant person. Thanks, Paul.
Thanks very much. We have a question about scenario 5, which you might remember was in relation to Roy and the appointment of a DMR, a decision-making representative from a panel. The question in relation to that was, in that case, when a decision is made, will there be another an accessible version of that decision made available to Roy, so Roy can himself ascertain what is taking place in that decision?
Yeah, so there's the order that comes from the court. So that's the formal document which defines what the decision-making representative, in this case, I think a panel member, is authorised to do. But I think that's an important opportunity to say that keeping the relevant person at the heart of decision-making is very much emphasised in this Act, so that the DMR appointed here, and we believe it's going to be a panel member, has that duty very much to involve Roy in decisions, to ensure that Roy is allowed to participate as far as possible. The guiding principles, the code of practice, spell all of that out, and that means being, accessible in your communications as well. So that's something that we would be very keen to emphasise. And that's, it's part of being a DMR. Even though you are taking decisions for somebody, you can't exclude them from the process, and it's important that Roy's understanding and his ability to participate is maximised as far as possible.
And I'll just sorry, Paul, I'll just jump in there to add something. The relevant person will be involved as much as they can be in terms of the discharge process, and that's in terms of documents for discharge will be served on the relevant person. An explanation of the process and what it's going to mean to them will be given. Their response, if any, will be recorded and submitted to the court. Also, any notifications in relation to their will and preference will also be recorded and submitted to the court and taken into consideration when the discharge order has been made.
Thanks very much, Alice. We're just coming up on 5:30 now, so I'd just like to say, on behalf of the Court Service and the Decision Support Service, I'd like to thank everyone for attending today and for their interesting questions. As I said at the outset, were so many questions we weren't able to get to them all during the session, but a frequently asked questions document will be produced to address the questions raised that we couldn't get to, and that will be circulated. There's also more information available on the Court Service website. That's courts.ie. If you search for the Wards of Court office there'll be more information. And I know, as mentioned previously, they'll be having some Q&A sessions and further sessions. So all of the information in relation to those will be available from the Court Service, the Wards of Court office. So that's courts.ie and search for Wards of Court. And there's more information on the Decision Support Service on decisionsupportservice.ie. So it just remains for me to say thank you very much for all the panelists for their contributions, and thanks for your interest to all the attendees.